As a loyal opposition, I want to thank the council very much for always giving us the opportunity to speak and raise our issues that affect this nomination. Our issues always are about transparency and openness of the process, and allowing me to speak shows just how open and transparent you are. Our concerns are always issues that have not been addressed yet. They often are once the council asks their questions, but in order for us to have our opportunity to have our say, this is where we have to speak. As always, we have same two major issues, but there's two other issues because of this going to the appeals court. Our two issues are misuse of restraining orders. The basis for restraining order, as we understand it, is that there must be reasonable fear of imminent serious physical harm. We've always asked that the nominees be asked if they know that's the basis. Recently, more and more nominees are answering the question correctly, and I think that's in a large part because of the work of the council, and I'd like to thank you for doing that. And I think that helps the whole process and helps the judiciary. Our other issue that this nominee perhaps has not yet addressed has to deal with family court and custody matters. But as appeals court judge, he will be addressing them. Currently, it's our understanding that custody matters are decided. 90% of the cases end up in sole physical custody. On reading the law and actually coming to these council hearings to understand what the process is, we fail to see how that's possible under the current law, and we think there's a real problem, opportunity for reform, and certainly as appeals court judge, it's an issue that he will have the opportunity to address, which comes to his role as an appeals court judge and the two issues that we see happening in the appeals court that concern us so much. First of all is the way that the appeals court addresses interlocutory orders. They cannot hear any of the cases. If you've read the case law, you understand the basis for why they won't allow certain interlocutory cases to come before the appeals court. But the practice appears to be, as we understand it, that they allow next to no cases. And this really comes back home to the family court. As we've all heard, the problems with the family court start with the temporary orders. If you don't have an opportunity to appeal it, there's no way to straighten out the problem when it starts. I would like to hear this nominee's view of interlocutory orders, particularly when it has to do with custody. As the council has made very clear, when these cases can go on for years, there is immediate harm, at least according to one council member, one parent is taken away from the children when it's a capable and fit parent, as we believe most parents are. So I'd like to hear this nominee's view about interlocutory orders in the case of custody matters and whether he'd be willing to address them. The other thing that concerns us is when people make appeals to the appeals court, oftentimes as an attempt to get through the process, it's heard before a single justice. They have to pay their fee, they put their arguments together, it goes before a single justice. We know that all too often they get no response. It's simply denied. We've heard before, when we talked about openness and transparency, how important it is to explain to people what's going on. I would like to see from a single justice, if they are going to deny appeal, that they at least give at least a one-sentence explanation as to why they're denying appeal. I really don't see what the value is of taking someone's fee, taking an appeal, and saying nothing except for denying. And
are you talking about interlocutory review being denied, or the
anything? Well, when you go to the single justice, it's usually interlocutory.
So you're talking about the denial by the single justice.
Yes. And basically any denial, I think there should be some explanation. Certainly the ones where the slips come up, there is a very lengthy explanation, and I understand that takes a lot of work. But if you look through the slips, a lot of things get denied outright, and there's no explanation to the participants or anybody who's looking at the cases. And I would like for there to be more transparency and openness on this issue, that there would be at least some explanation as to why it was being denied. Those are the four issues that we have concerns of. If you have any questions about them, I'd be happy to explain, but we certainly hope to hear questions asked about them.
Thank you, Patrick.
Thank you. Let me just use my prerogative here and see if I can put Justice Bono on the spot a little bit. Did you hear the concerns here? Can you explain a little bit for all of us here about how the appellate process works with interlocutory orders in matters before a single justice?
Well, there is a statute that provides for interlocutory review of certain orders that are issued by the trial court, superior court, district court, or the probate and family court. And when the single justice with one appeals court judge who sits for the entire month and listens to these petitions for interlocutory review, as well as other petitions that come up and from other avenues. What probably the most important thing to understand is that the single justice does not have a wide breadth of authority to change decisions or to grant interlocutory review. It is rarely granted and only granted in the most extreme or extraordinary circumstances. We can only do so when we see that the trial judge below has either one, abused his or her discretion, or committed a clear error of law. And as you can understand, that does not happen very often. It happens upon occasion, but we do have fairly good trial judges, and as you know by looking at the appeal court decisions and the decisions from the Supreme Judicial Court, trial judges are reversed only about 25% of the time. About 75% of the time they are affirmed. So in any event, the interlocutory review process is a different process. The standard of review is extremely difficult for the litigant, but I can assure you that the single justices of the appeal court do take all the petitions that come his or her way very seriously. They are not looked at and decided upon by the clerks. The single justice reviews every petition without a doubt, and I would be happy to make clear that the simple denial with the absence of an explanation is something that the public is concerned with, and I'd be happy to take that message back. But you really should understand that it does not mean that it hasn't been given its full review and full consideration by the court.
Thank you very much. We appreciate that.
Thank you very much.